In this presentation, we will present to you our case review for the case of SYMBION International Sdn Bhd and others versus MAH CHEZ YONG and others 2019 MLJU 2091 under the topic of Director. This is the list of our group members. From Group 1, Muhammad Azim bin Muhammad NAJIB, Syifa Amali binti Muhammad AZLAN, Nur Amni Syahirah binti KHAIRUDDIN, SYAZWEENA binti SAZALI, and Nur Aziemah binti Rosle.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Azim bin Muhammad NAJIB. My matric number 057317. I will present on the facts of the case. The first dependent was the plaintiff former group CEO from October 2014 until his retirement on 14 June 2017. The plaintiff claimed the first defendant breached his fiduciary and integrity duties to them throughout his term as CEO. Employees of the plaintiff companies never reported to the board of directors. They reported directly to the first defendant. The first defendant was responsible to board of directors for all his acts. The plaintiff can pay by check or internet transfer. The check must have Datuk Jennifer's signature. The first defendant can make online transfer at any time because he has board of director clearance. All transactions were paid via internet transfer. Mr. Chong Chen Yang has the data token to enter transaction, whereas the first defendant has the authorized token to approve transaction and send money. Jennifer cannot control internet money transfer. Then, this company's sole purpose was to issue false invoice to the second and fourth plaintiff in order to obtain access to RHB Bank's Berhad Bankers Assistance Facility, or known as the BA facility. The fourth defendant will then pay the second or fourth plaintiff back the amount that they had borrowed from the BA facilities, depending on which of the two plaintiffs requested it. It is the responsibility of the second and fourth plaintiff to pay back the BA facility. The first defendant's wife and mother-in-law are the second and third defendant, respectively. Owners and director of both the fourth and the fifth defendants, respectively, are the subject of this lawsuit, but the fourth and fifth defendant will always manage in accordance with the first defendant instruction at all material time.
Hi and Assalamualaikum. My name is Nur Amni binti KHAIRUDDIN and my matric number is 057350. Based on each transaction as mine, the court discovered that there was an immoral act on the part of the first defendant. Most of the transactions, by the totality of the evidence, pointed out that the first defendant did not only obtain consent from the board of directors to contract on the transactions, but he also was proven to not act with reasonable care, skill and diligence in section 214 of the same act by involving a company owned by his wife and mother-in-law in most of the contracts. The court also deduced that the second defendant, the wife, was guilty of knowing assistance of her husband fraud when she purposely closed her eyes when her husband did all those unethical deeds in transaction. At the end of the judgment, the court concluded that first defendant had breached its duty as a director provided under Section 213 of the Companies Act to the plaintiff, the company. The court then awarded the plaintiff's interest on the sums of 50,000 ringgit against the first, second, fourth, and fifth defendants jointly and severally. Meanwhile, the claim against the third defendant is dismissed with cost of 10,000 ringgit. And lastly, the counterclaim is also dismissed with the cost of 10,000 ringgit, and all of the above mentioned sums are subjected to the allocator.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aziemah binti Rosle and my matric number is 058471. So, I will explain to you guys about the ratio decedenti that we found from this case. The counterclaim is dismissed and the costs which are subject to allocation are 10,000 ringgit. First and foremost, the judge has reached the conclusion that the second defendant, who is the wife of the first defendant, is responsible for knowing assistance. Any ethical man would recognize that the first defendant was operating in a manner that was contrary to his obligations of loyalty and trust owed to the plaintiffs. As a consequence of this, the court finds the fourth and fifth defendants guilty on the basis of the notion of knowing receipt. Wong Chilin judge referred to the case of Oi Man Kin and Amanah Scott's Properties KL Sdn Bhd, where one of the elements for knowing receipt is the defendant has information that the assets obtained can be traced back to a breach of fiduciary obligation. On the contrary, there has been no evidence brought forth against the third defendant. With the exception of the payment for the purported corporate car, there is also no sign that any money is transferred to the third defendant. Moreover, there is no proof to suggest that the third defendant is even a check signatory for the fourth and fifth defendants. As a direct result of this, the judge does not conclude that the third defendant is liable. Additionally, the counterclaim of first defendant is dismissed with cause since the first defendant has shown no evidence to support his claim. Datuk Jennifer and the first defendant contracted, but Datuk Jennifer itself is not sued. Since the plaintiffs here are not privy to the claim contract, they cannot be held accountable for the contract breach. The judge is of the opinion that the first defendant has failed to prove that there was a breach of contract. He stated that transferring shares necessitates that the plaintiff's profitability, although court documents show no profits from 2015 until 2016. The first defendant also claimed that he was owed 2 months' wages, but he never presented any evidence in support of his allegation.
Assalamualaikum, my name is SYAZWEENA binti SAZALI and my metric number is 058782. Now I'm going to continue and explain further pertaining to ratio descendant in this case. First and foremost, the first defendant is legally obliged to pay the claim amount since his counterclaim is dismissed. And the second one is the plaintiff additionally claimed RM1,298.50 in rental payments for an oxygen concentrator rented from the second plaintiff by the first defendant. Also, the first defendant does not dispute this claim, but he contends that the rental should be reduced from his alleged 2 months' wages of RM40,000 as stated in his counterclaim. The aforementioned reasons reveal that won't challenge judge reliance on legal reasoning in deciding this case. As for the reasons that have been stated previously, and in the light of provisions and cases that relevant to the situation, the court has reached the conclusion that the plaintiff have been awarded interest on the sum authorized as requested, as well as RM15,000 in costs against the first defendant, the second defendant, fourth defendant, and the last one is fifth defendant jointly and severally subject to the allocation. As a result, the counterclaim is dismissed with cost of RM10,000 which will be allocated by the allocator. So, the ratio descendant in this case can be summarized as what the defendant breached their fiduciary obligations and failed to tender evidence to defend themselves, and because of this, the defendant will held accountable in this case.
Assalamualaikum warahmatullahi wabarakatuh. My name is SYIFAA AMALIN binti Muhammad AZLAN. My metric number is 058502, and I'm going to discuss about the legal opinion for this case. Generally, directors owe fiduciary duties towards their company. But according to this case, does a CEO are the same as directors? The answer is yes. As per Section 210 of the Companies Act 2016, which expand the definition of a director that also includes the position of a CEO. Therefore, in this case, the first defendant, in his term as a CEO, also can be regarded as a director according to the provision. Subsequently, he is subjected to the duties provided under Section 213, where the provision evidently provides that their fiduciary duties are to use powers conferred to them for the company's best interest by exercising reasonable care, skill, and diligence in everything they do in the company's name. In other words, the directors are bound by fiduciary duties to their company. The case of Neary against Deans of Westminster explained further to the regards of fiduciary duties, where it concluded that when a relationship was based on a mutual obligation of trust and confidence, such relation is called a fiduciary relationship, in which it does attach a responsibility that he must act solely for the interests of his employer. Thus, if such relationship exists between the parties, they are said to have a fiduciary relationship in which attached to them are fiduciary duties. Then in Section 214 of the same Act, establish how directors and CEOs should exercise reasonable care, skill, and diligence in carrying out their duties to the company. directors are identified to have done their duties when they first make the judgment in a good faith for the company's purpose, second, does not have any personal interest in the business decision, and third, he is informed about the subject matter of the judgment to the extent he believes is reasonable in the circumstances, and fourth, lastly, he had a reasonable trust in the judgment that such judgment is in the company's best interest. In short, it is with great confidence that we can express that the court does not err in making the decision, as the defendant had not accomplished his fiduciary duties towards the plaintiff, SYMBION International Sdn Bhd. That's all for me. Thank you.
We hope that through our presentation, you guys can gain some new knowledge and obtain positive results from this case as an outcome from this presentation. Thank you for your time and consideration. And lastly from us, have a pleasant day. Thank you and bye-bye.